Hello and welcome. This is Attorney Brad Micklin. I'm the managing member of the Micklin Law Group, which is a law firm concentrated in divorce, custody, and family law issues, and located in Nutley, New Jersey. As hopefully many of you know, I do a number of different videos. I do a daily tip each day with a very short piece of advice. And I also do monthly webinars that goes into a certain topic in much greater length. This is part of what I usually call like a how-to series, where I try to give a little more advice on an issue which is broader than my daily tip, but a little shorter than the webinar in case you don't have 40 or 50 minutes to actually sit and review. So today's topic, I'm going to discuss briefly the issue about relocation of custody and a recent case that was decided in the appellate division called Bisbing versus Bisbing. That's B-I-S-B-I-N-G. I don't have the case reference offhand. And it's important to note, as with all my videos, that I'm discussing the law at this date that I'm discussing it, where you could be watching this, months or years later, and the law may change. So it's important to know today is December 20, 2017, and relocation, as well as any other law, is always subject to change. But currently, and relocation is obviously a very sensitive issue, so it's important to have a good understanding of the issue if you're going to be facing it on either side, whether you're moving or if you're the parent who may be losing custody. Now, essentially, there is one or two different standards that are utilized when a parent is looking to relocate. Essentially, the most common one is under a case of, I'm just going to simply refer to it as Bowers. And that sets forth 12 different criteria that's supposed to be established in order to permit a relocation. And those are essentially boiled down to the courts trying to determine, one, if the move is proposed in good faith, two, that it's in the child's best interest, and three, it's not going to harm the child in any way. Now, that's for your customary or traditional type of parenting time where one parent, the parent who's relocating, has primary physical custody. If you're sharing physical custody, and that doesn't necessarily mean by time, but time and or responsibility, it has a different standard, and that's usually more the best interest of the child standard. Now, the reason why the Bisbing case is important to discuss now is because a lot of people are starting to construe that case as if it's changing the focus of the Bowers and relocation test, and I don't think that it is. First, by way of background, Bisbing versus Bisbing was originally a trial court level case, which is where all cases start. The change comes from the appellate division, which is the higher level. So when you have a normal case or you're involved in litigation, you will be at what's called the trial level. And when it's taken to review by a higher court, it's the appellate division. So ironically, I actually represented the father in Bisbing when it was at the trial court level. And they had recently been divorced for a short period of time. Mom had custody. I don't recall if it was an equal shared parenting time, but I know it was an equal shared relationship, where my client, the father, was equally involved in the children's lives. And what was unique to this case was they had a settlement agreement that specified many things about parenting time that were unique. And they indicated, for one, that children are best served by being equally with both parents. They had a provision that actually limited relocation because it would be harmful to remove the children from their relationship with either parent. And there's also an underlying law that exists in New Jersey at this time that says or suggests that if custody is resolved by way of a divorce agreement and another parent seeks to relocate within the 1 year following it, the court may presume that it's being done in bad faith because it could or should have been known at the time of the divorce. And had the other parent known that intention, they might have changed parenting time. So the court views it that the parent who was planning to move sort of withheld the information so they could get an advantageous custody arrangement. So that was part of what's underlying, because in Bisbing, the mother was seeking to relocate within the year from the time this agreement was entered, and the agreement, as I mentioned, had these very specific terms indicating harm to the children if there's going to be relocation. So long story short, we took it to the trial court to prevent the relocation. The judge denied our request, granted the relocation, and probably what was one of the worst decisions I've ever seen by a trial court. Fortunately, when my client took it to the appellate division, they agreed with us and reversed it and sent it back. Now, the important thing about this case is the decision is being interpreted by a lot of lawyers, and I've even heard some judges who say that they believe Bisbing is changing the standard to be more of a best interest of the child analysis and not so much of the Bowers 12 factors. I disagree, and I've reread the case on the appellate level several times. I think what's important about that case, the appellate division, is the underlying facts of the Bisbing settlement agreement that are unique to most settlement agreements about custody. The provision about not relocating and it being harmful to the children, the fact that they had an equal shared parenting time arrangement, and it was done within the year, which suggested bad faith. I think all of these factors that are not mostly unique to this case, but that were present in this case, greatly affected the decision in Bisbing. I don't read Bisbing as changing the analysis under Bowers or the best interest standard if you're sharing physical time. Now, Bisbing is a new case. It only came down, I don't know, within maybe the last year or so. So its effect hasn't been implemented entirely, and there's been no challenges. So law about everything is always subject to change. And I think there's going to be some future interpretations regarding this. Now, what is important to note is whether I'm right or wrong about the effect of Bisbing, the case itself is promoting a lot of people to talk and look at relocation differently. And I think that alone is going to possibly change people's views about the rigidness or the appropriateness of relocation. And I think there's a greater recognition of the other parent's involvement in the loss of a child's relationship by being forced to relocate. So I think that the tide may be changing, and I think the courts are going to start looking more rigidly at relocation and denying them if there's really not a great interest that's served, excuse me, for the children. So for more information on this, you can always go to my website, which is micklinlawgroup.com. That's MICKLIN lawgroup.com. You can also call us at 973-562-100. I'm also starting a new service. Excuse me, I'm just getting over a cold. You can also text MLG to 72,000, and you'll get some automatic information updates, and you'll have also a downloaded text message where you can message communications to my office about questions and meetings very easily from your cell phone. Hope this was helpful, and let me know if there's anything else that you might be interested in by messaging me, as I mentioned before. Thank you.